gives us just lights. Good afternoon, I'm Chief Court Local Friedman, P5615 on behalf of Davis, Bradley, Stephen, Judge.
Bradley Allen Davis.
Your Honor, today's date and time set for sentencing. I reviewed the PSI. Judge, the content of the report itself is accurate. There's really nothing that needs to bring to your attention in terms of the accuracy or any omissions within the report. I have some thoughts I'd like to share with you for my client as a statement you'd like to read to your Honor.
Very good.
As indicated, he's 49 years old. He's been in trouble with the law, but it's been quite some time. And I think that's kind of the theme here. He's got a 19-year-old son and a 17-year-old daughter. So when you talk about an opportunity to teach our kids and do as I do and don't do as I don't, this is the situation. He's embarrassed by his actions. Not only did he drink and drive, he drank and drive from out the scene. Pause for a moment. Sorry. Sure. As I was indicating, he drank, he drove, he left the scene. No, nothing good. The good that's come out of it, it's been a learning opportunity, a teachable moment for his children. He's been compliant with testing, there's been some accommodations to help. He's very successful in his career. He is in counseling with Richard Smith at Smith Counseling Center, so he's taking to that. He has some medical issues. He spent some time speaking to probation. He has refrained from use of marijuana ever since the imposition of bond. There's no use of marijuana. Obviously, there were some positive tests that came up early, but they haven't tested. He hasn't tested positive because he stopped using it. But it's a medical issue. He has a legitimate card from his primary care doctor. He hasn't used marijuana because he's in compliance with his court, but he has the card. Probation officer knows about it. He recommended it. He was surprised, but definitely wanted to do it and get it. He has not used it, which I think speaks volumes.
Smart.
There were 2 missed tests, PBTs, on 13th and 14th June. And it's a unique ask I'm going to make you around. He was stuck in an event. He didn't drive, and he couldn't get a ride home because the person that was driving him was not ready to leave, and he thought they'd been drinking. So he couldn't go home and test. What his ask is, Your Honor, is to remove the sober link and actually test traditionally by calling in the morning and going to the facility. He thinks that will actually work for his schedule to get it out of the way in the morning and then have to deal with it midday. Other than that, Your Honor, I think that the recommendation is fair. It's certainly referencing his priors. I would ask if Your Honor would consider 24 months. I know that there's the midway point. I know Your Honor's position on that. I would ask for a reduction off the bat, something closer to 12 to 18 months. This is somebody who can't afford to get in trouble. There's too much at risk. And he knows what he's done. He's taking full responsibility. What this has shown him that is while he had these problems in an earlier life, they're still there. And he has to address them. He can't just address them in his way. He has to address them therapeutically, and that's what he's working on. Thank you.
Given the nature of the offense, prior contacts with drinking and driving, there are 2 different versions of events that the court could conclude about the June 13th, 14th EBT issue. Obviously, we have June 13th, he misses the 10 o'clock test. And then he misses the 7 a.m. test the next day. I think he's testing 3 times a day. If I remember correctly, is that right? So the middle of the day test is what time?
2.
Okay. 2 o'clock on June 13th. till 2 o'clock on June 14th. I have no idea whether you were drinking at the graduation event or not. And so it is either the version of events that you gave, which, by the way, if this version of events is true, that was a responsible decision to make, right? Not to put yourself in the situation where someone was driving you who was under the influence and not risking driving on a suspended license, all right? Based on the nature of the offense and your prior connection with alcohol, another conclusion could be something happened that court, you would not want the court to know. All right. And so that's the situation that I find myself in and trying to navigate. Because given what happened here, the bodily alcohol content, the hitting a vehicle, the leaving the scene, all of those things, Mr. Davis, that's a recipe for a jail sentence. Like, this court tries to avoid wherever possible the upfront jail sentence if it can, because I want to keep people working, I want to keep people in treatment, I want to keep people in a position to heal. And I reserve jail for those circumstances that call for basically grabbing somebody's attention. This is a situation where I would normally consider a jail sentence. Mr. Friedman has put you in a position where the court has hit the pause button and said, all right, well, I believe we have a lot of things in place that would help heal and grow and suggest that you are in a position to embrace accountability, that you don't need a message sent from this court. You get the seriousness of this. But I've got that combined with that odd situation on the 13th and 14th. There's a lot of question marks that are going on. But I remain hopeful, and I am curious about what you have to say about the incident that brought you here, what's going on with you and your sobriety, where we go from here.
Well, first off, I want to sincerely apologize to the court, to my family, and to the community for my actions. I take full responsibility for the decisions that brought me here today. There's no excuse for drinking and driving, and I understand how serious this offense is and the potential harm that I could have caused. I'm lucky that there was no more damages done to anyone or anything. I'm especially ashamed because I know I'm better. While my prior offenses occurred many years ago, I recognize that this case shows I still need to address my relationship with alcohol. Since my arrest, I have committed myself to sobriety and making meaningful changes in my life. I'm determined that this will never happen again. My kids mean the world to me, and I work every day to try to be the best role model that I can. My children, 20, he's aged a little bit since the last result, and 17 are aware of the situation that I've created and that I have not practiced what I've preached to them both since they've obtained their driver's license. My hypocritical actions have made me evaluate life lessons I've tried to instill in my children since the day they were born to make sure that I'm always teaching them to be the best and most productive members of society. I have far too much to lose in this one life I've been given to make such immature decisions. I respectfully ask the court to consider not only my mistake, but also the actions that I've taken since then, and to know that I will be a better person for having been in this unfortunate situation. Thank you for your time.
Mr. Friedman, to see that much of a gap between his initial incidents and where we're at now.
Right.
And it's just a reminder to us that alcohol-related issues, they lie in wait. You know, it's almost as if they wait until a point in time in your life where it's going to do the most damage, and then they reveal themselves. But it's what we do from this point going forward that will, I think, define whether or not Mr. Davis will be in front of the court again, whether Mr. Davis will be able to, like he wants to be there for his children, and mainly take care of himself. It's going to depend on what you do from here. And I have high hopes, but I'm also very, very cautious. And so please don't mistake any level of increased or enhanced supervision as a sign that the court doesn't believe that you have the capacity. Far from it. My expectation is that not only does the community demand the very best from me, but you demand it as well. And so I'm going to put you through your paces. I'm going to challenge you. And when you're done, then you have the confidence saying, my sobriety's been tested. I know that I'm in a good spot with it. I know that I'll be able to go forward and rely on this program that I've built. That's my intent. Sentence in this court. You know me well enough with these kind of facts. I'm going to start at 24 months. You know, I'm sure that you've made that very clear to your client. It's always good to ask. But I'm telling you right now, Mr. Davis, 24 months is written in pencil. All right? Whether it's 24 months depends on you. All right? I have lots of, you've been here today. I have lots of people that need the court's assistance. It would make me very happy if, you know, shortly either, I mean, with these facts, a year will be a tough sell. But have I seen individuals in your situation step up in a year and make it very clear that they don't need any further supervision? Absolutely. Do I think you have the capacity? Absolutely. I make no promises, but it's right there. It's a $500 fine plus $350 in court costs, $125 in state costs. There's a $100 screening fee plus arrest costs and probation costs. On the failure to report an accident, it's a $100 fine. It should be $100 court costs. Plus $125 in state costs. I will authorize a long-term payment plan. All right, I'll suspend any jail time. I'm going to bet on you, Mr. Davis. I'm going to bet on the fact that the 13th and the 14th was exactly as you described. Maybe I'm wrong. If I'm wrong, if the court was played, it'll reveal itself. But I'm going to choose to believe that it was a responsible decision that you made at that time, because I have seen no other positive tests as far as alcohol goes. I wanted to enroll with intensive outpatient treatment and attend support group meetings as directed by probation. 40 hours of community service, maintain employment, attend the victim impact panel, no alcohol, marijuana. Hang on a second. So is it his intent to utilize medical marijuana?
Yes.
Okay. So no alcohol or illegal controlled substances or any mind-altering substances. There will be no violation or positive THC test as long as two things. One, we have the card. And two, you journal your use. You are protected under the law for use pursuant to the card. You're not protected for recreational use. And it doesn't have to be like a long, you know, War and Peace journal. All I need is I used it on this date for this symptom in this form. Straightforward. And then submit it to your probation. Submit to random screens, no bars, clubs, liquor stores. Any violation could result in up to 93 days in jail. Mr. Davis, I'm trying awfully hard to avoid that outcome, and I believe that you are as well.
Yes, sir.
My goals here, of course, are to reduce the risk of recidivism, achieve and maintain a sober lifestyle, and complete a rehabilitative program. That's it. Any other questions or concerns, Mr. Friedman?
Your Honor, is he allowed to resume regular?
Oh, I'm sorry. Since I didn't order the sober leak device, I should have made that clear. I struck that requirement, and then he can do ETGs twice a week. And I'll set it for a review in 90 days, and I'll consider a further reduction in his testing if he continues to make improvements.
And then, thank you, Judge. One other question. You asked that he ordered enroll in intensive outpatient treatment. Can he continue with Richard Smith?
Well, absolutely. I think Richard can step up he's done IOPs before. IOP is just, it's going to be a little bit more enhanced level of counseling, but I definitely would want him to stay with Richard Smith because we had a successful relationship there. I wouldn't want Mr. Davis to try to establish a whole new relationship with another counselor.
Right.
I think he could do it.
Okay.
And if he can't, then or if he's not quite sure what the court wants, he knows us. He knows us well. He can reach out to us and say, well, what if we did this, or we met for this period of time, or I threw in an extra counseling session. We might just say, you know what, that will fit the bill. Usually an IOP is a pretty intensive counseling, but I have confidence that you and Richard Smith can come up with a plan I can get behind. Fair? All right. Anything else?
That's all.
All right. Good to see you. See you in 90 days. All right.
Your Honor, I know you've got a busy courtroom. Still wondering if that sponsor might be willing to speak with one of the other clients.
So he's been out, can we approach real quick? Bishak. 26000557.
Good afternoon, and Felix, E73261, hearing on behalf of Mr. Bishak to say your full name to the court record.
Michael Bester.
All right. 26000557. Please have separate sentencing. Mr. Dalek, where do we stand with the report? Any additions, deletions, or corrections?
Nothing to add or remove.
All right, as to the recommendations?
We have discussed the recommendation as well as working to differentiate between this court's jurisdiction and the Secretary of State. Got there. And Mr. Bishak is familiar with the probation for better or for worse, and he has successfully completed it in the past, and here to he pledged take responsibility for his actions. Anything the court might consider to reduce the financial hardship related to the particularly logistically, he had been working delivering pizzas, and he won't be eligible to drive again for at least a year. So now all the transportation responsibilities are falling to his mom, who's here, who lives with, who has to leave his and when he needs to get somewhere. So again, he's prepared to fulfill all the requirements of probation, and hopefully do those in a way that don't create a hardship for anyone else in this family.
Does he have support here today?
He does.
Who's here with him today?
Mom and Frank. Mom and
This early on in the process, I received a letter from Marilyn Bescheck, right? And I know that there was a request to try to prevent him from going to jail, and also for him to not lose his driver's license. So I do have direct control over whether he goes to jail. I do have direct control over that. I have no control, unfortunately, about his driver's license. There's nothing that I can do to assist him. That's just from the Secretary of State. Once a person has this second conviction, that's it. Then there's once that happens, I can't help him. There's nothing I can do. It's a mandatory Secretary of State. So I mean, Mr. Bescheck, it's hard to say this, but the reality is that you made a set of choices again. You decided to drink. You decided to get behind the wheel of the car. You decided to put yourself and others at risk. And we had done some good work together.
Yeah, really sorry for that.
And this is a reminder. I mean, you've seen today some of the sentencings. We just had a guy who was sentenced and he had a drunk driving and 25 years, and all of a sudden alcohol came up again. And I mean, he had to pay a significant consequence for that. So, Ms. Bescheck?
Yeah, I just wanted to let you.
I can't let you do that, Ms. Bescheck. I'm sorry.
I just want to apologize for what he did. You know that he did wrong. And he's put himself, in a lot of, he's really upset with himself. And I'm also upset with him too for what he did and everything. All he had to do, is whatever, that day that he was drinking. It was like 2 days before his birthday. I had bought all this stuff for him for his birthday and everything. I've got brand new wheels for his truck and everything. And it all fixed up for him. There's still, a few things that need to be done to it and everything. And now, since he can't drive it, is just sitting there, and the tires are starting to go low and stuff, and, you know, it says you can't, you know, drive or anything like that, truck it, you know, has to be fixed and stuff like that, you know? So it's just sitting in the driveway, you know? I know, you know, my sister and everything, she was in a bad car accident. And Michael's been helping me a lot with her and everything because she lost, you know, her left leg. And, he's been helping me, you know, do a lot of driving and stuff like that, you know, take her back and forth, you know, to the hospitals and stuff like that. And I'm gonna, yeah, just done myself within the next few months where I'm not gonna be able to drive or anything. And Michael was my, you know, my driver, you know, to bring me back, you know, after I have, you know, what I have to have done and stuff, you know. So, like my doctor's appointments, I'm gonna have to like put on hold because I don't have another driver or anything like that, you know, to bring me home. You know, I can get myself there, but Michael was, you know, my transportation to bring me home, you know.
Like I said, you know, the law is unforgiving
Yeah,
when someone gets 2 drinking and driving offenses within 7 years. There's no wiggle room, there's no way around it. And so everything that you're saying is frankly heartbreaking and difficult to hear. Unfortunately, he's done this to himself.
I know, that's what I told him. I said, even when, you know, it happened and everything, and I asked him, you know, I didn't even know that he was in jail. You know, I got a call on my phone and I looked and I saw, you know, where the police and everything. It's like, I didn't know what happened or anything like that. I couldn't get a hold of him. He called me like 27 times. I couldn't get a hold of him because I didn't know, you know, how to get, you know, get to him. And he had told me, you said he was in jail, you know, after I got a hold of, you know, the,
Mr. Fraley, could you
lady they'll talk to and everything.
will you approach, please? Hold on one second.
Sure.
And they had, you know.
Hold on one second. Real quick.
Do you want to pass it? Just give us a moment. Yeah, right. Which I don't think it's a long conversation. Okay.
All right, thank you, Ms. Peschek. Mr. Peschek, have a seat outside. Your attorney wants to talk to you for a minute, okay? Can you call Sarah up here, please? So Mukhtar,
They're in the hallway. I'll open it.
you can real quick. Sorry, Mr. Zucky,
Okay, Judge, I was late.
I had a window.
I'm sorry. Yes.
All right, 26-00112.
Good afternoon, Your Honor. Ben Werble, AP 64889, on behalf of Mr. Talukdar. He's to my left, Your Honor. Your name for the record.
All right, today's 8 times under bond review. We have a bond violation allegation that he is falsifying his PBT law.
Not aware of that, Judge. Didn't see any documentation to that effect.
Here, I'll
Sure. Oh, sure.
yeah, that's another line. So.
Okay, I'll get that. Okay, thank you.
Thank you. All right, Mr. Talukdar, we need to go talk to your attorney for a minute. Okay. Will you approach Sarah real quick?